Kula Friday. Yeah.
So hello and welcome to Conversations with Esther. Today, the 16th of April, 2025. We request that we all remain muted, of course, except our speaker. Let us begin with a word of prayer. Father, in the name of Jesus, we thank you for this session tonight. We pray that we will learn, relearn, and unlearn, that we will be open to learning new things. We thank you for our speaker. Lead him and guide him in Jesus' name. Amen.
Amen.
Good. So allow me to share this on the screen just for those that would possibly be joining us for the very first time. We would like to introduce to you Conversations with Esther. Now, my name is Esther Katiba, the CEO and founder of Conversations with Esther. Now, Conversations with Esther is an impact-driven professional platform that informs, educates, and rebuilds mindsets on matters work, organizational culture, and holistic wellness. We ignite ethical and authentic leadership, promoting best practice within industries. Conversations with Esther equips the workplace with relevant legal, human resource, and holistic wellness skills through capacity building, training, motivational talks, end-to-end HR consultancy support, and mentorship programs. Now, guided by our three values, integrity, excellence, and impact, we envision a workplace transformed by professional conversations, respectable relationships, and intentional leadership. Now, Conversations with Esther, as I've mentioned, works on the HR, the legal and wellness circles. Now, this is our 7 pillars of wellness. Now, we drive wellness as well in the workplace. And I know we can have everything else working, but as it is today, there is a need to focus on employee wellness as well. So we use this wheel to drive wellness. We use it to also customize wellness programs for you in your workplaces. We deal with your physical wellness, mental wellness, financial wellness, social wellness, spiritual, environmental, and intellectual wellness. So you can reach out to us. Every year we have a calendar of activities or events that is over and above our training, our mentorship, our HR and legal. We also have wellness events. Now, we just did our nature walk at Karura that was very successful. On 26th of April, we are gathering at the Nairobi Children's Park, Nyerere Road, for a team building and networking event. It's absolutely free. I know our admin is on the call and she will share that poster for that event. Come, let's team build, let's network. Physical wellness event on 31st of May, 28th of June, we'll have environmental wellness activity, a hike on 26th of July, facing our fears, daring activities in August, movie and bowling day, 27th of September, mental health awareness event on 25th of October, and we close the year with dinner and awards for wellness champions on 29th of November. It's finally here. It's finally here. And I know many people have asked, Esther, are you not doing a conference this year? Last year, we did a conference that was very successful that spoke to aligning organizational culture with strategy. Now, this year, we are speaking to navigating employment and labor relations in Kenya. This is a place and a spot that most people would really want to secure. It's finally here, conference. Kenya has a fairly complex labor law framework that often poses a challenge on how we manage the employee and employer relations from entry to exit. That speaks to the employee life cycle. Now, from a contract of engagement to workplace policies, statutory deductions, collective bargaining agreements, separations, occupational health and safety, dispute resolution procedures, and much more. Join us for a 3-day conference as we interact with Kenya's top employment and labor relations judges, court judges. Our speaker tonight will be speaking at the conference. You can't afford to miss this one. We will have CEOs from top organizations in this country. We will have legal professionals. We are inviting HR professionals, health and safety professionals, legal, business leaders, business owners. Now, listen to this, and I know our speaker will be speaking more to this conference as well, because he's getting ready to speak to us. We get the opportunity at the conference to walk through case laws, providing practical interpretations to current real issues within the workplace. So feel free to email us on training@careerrootsolutions.com. You can secure your table as an organization. You can secure your slot as an individual. Navigating employment and labor relations in Kenya. We will be meeting on the 4th to 6th of June, 2025 at Sawela in Naivasha. Now, our charges are very fair. That is 65,000 for all those days. The pay bill details are right there. For HR professionals, you will get your 4 CPD points. We are in touch with IHRM. We are NITA certified, so we can have that conversation. So don't miss your slot. Begin to secure your slot. Tonight, meet Honorable Mr. Justice Jacob GAKERI of the Employment and Labor Relations Court. Now, our topic tonight, of course, will touch on what we will be speaking on the conference. This is just one of the areas that we will also be speaking to. We'll be looking at issues in the conference. We'll also be looking at those real issues that you're having in the workplace. Justice GAKERI and many others will walk you through it. They will also help you with the real issues you're having in the workplace. So tonight, what does the Employment and Labor Relations Court expect of the employee and employer during separation? This is usually heated. I don't know, Justice GAKERI will tell us. When we join an organization, the relationship is very good. When it gets to separation, I don't know what happens. In Kenya, termination is governed by the Employment Act, which lays out clear guidelines to protect both employees and employers' rights. How then should we handle separation to avoid legal pitfalls? Now, our guest, Justice Dr. GAKERI, is one of the judges serving in the Employment and Labor Relations Court of Kenya. He previously served as the Secretary, CEO, Council of Legal Education, having served as Director, Quality Assurance and Director Examinations, before which he was a Senior Lecturer, School of Law at UON. Dr. GAKERI holds the LLB and LLM, University of Nairobi, LLM, University of Houston, and a doctorate from Indiana University, Bloomington, USA. Dr. GAKERI is a certified public secretary. I will stop sharing and give the floor to Justice GAKERI. Justice GAKERI, thank you very much for making time. The floor is yours. We are ready to learn.
Thank you very much, Esther, and welcome participants. As Esther has indicated, she called me to talk about what the Employment and Labor Relations Court expects of the employer and employee in cases of separation. And there was another one, how to handle separation to avoid pitfalls. That question, if asked, and one expected a quick answer, which is an answer all the same, when we say, well, follow the law. It will be as simple as that. Follow the law. Look at what the law says, follow it. But that answer would be incomplete and patently inadequate because the general scheme of things is different. To approach a topic on separation, it is important to start where the employment cycle begins. That is at the hiring stage. I want us to remind ourselves some basic principles of contract, because the employment relationship is a contract like any other. And a long time ago, when most of you and I studied some law, we were told that a contract is a legally binding agreement made between two or more persons. And the employment contract is a legally binding agreement made between an employer and an employee. And analogous to any other contract, this contract confers rights and obligations on both parties. However, this contract is a special contract to some extent in that it is regulated by law. And that relationship has now been elevated so that the right to work is now a constitutional imperative, and there are rights that fall under that right to work. In understanding a separation, it is important for employers and employee to understand their contract, whether it's oral or written. Of course, the law permits employers to have an oral contract, one entered into by word of mouth or in writing. Those are the provisions of Part 3 of the Employment Act. Whereas oral contracts are good if they serve their purpose, they are not very good, particularly if the duration is beyond the 3 months prescribed, or the task cannot be completed within 3 months as the law provides. So it's always good to have something in writing, something which shows that there was a relationship. Not that an oral contract cannot be proven, no. In fact, if you look at the definition of a contract of insurance, a contract of employment, which is a contract of service, it can be implied from documents, it can be implied from conduct of the parties, for example, payment of salary and the others. And we see this every other day in court, where parties come and they don't have anything to show. Sometimes nothing at all, nothing. But from the evidence, one can discern and make inferences that there was a relationship, depending on how the evidence is. In some cases, there is no evidence at all to show that there was an employment relationship, because an employment relationship is not a social relationship. It is a legal relationship, so that it must be proved to the satisfaction of the law that indeed there was an employment relationship. The terms of an employment relationship, of course, are not only those terms that are agreed upon by the parties, if it is in writing, because once an employee joins, the other terms that are incorporated into the employment relationship are the impact on the separation. This would include the HR manuals, the career progression guidelines, and the others. Those become part and parcel of the contract, and they bind both parties to that contract of employment. So the employer must obey them as the employee. And other than the HR manuals and other internal documents and policies and regulations, some employers have regulations others have policies, others have manuals. The title does not matter. They are still part and parcel of the contract. And there is case law, which appreciates that position. The other terms that are incorporated in the contract are if an employer and a union have a CBA, the terms of the CBA become an integral part of that contract of employment. And CBAs are typically very comprehensive because they cover every aspect of employment, including redundancies and termination generally, and that becomes part of the contract. The contractual terms don't have to be changed to incorporate the CBA or the HR manuals. They are still part of the contract. So it behooves the employer to ensure that the employees are aware of all the contents of these documents. If there's a CBA, of course, CBA, the union does a lot of work in ensuring that the members are involved, although they may not appreciate the details of the CBA, but it is important for the employer to endeavor to ensure that employees are aware of the terms of the CBA in relation to the various aspects of the CBA as agreed upon by the parties. And the same applies to the HR manuals and policies or regulations that an employer has. Typically, these are concluded in consultation with employees, but all employees ought to have access to these documents. Either they are given hard copies or they are shown the repository if it is online, as most employers do. A very important, and this should be the last part of my introductory part, a very important part of the contract of employment is clarity of the terms. Are the terms clear to the employee in particular? The employer may be well aware of the terms of the contract. The HR person is generally well versed with the terms of the contract. Different. But clarity is important. The employee must know what are the terms of the contract. Even if it means going through, of course, the law imposes a duty on the employer, just in case the employee is unable to discern what the terms of the contract are. So excuse me, the law imposes a duty on the employer to ensure that the employee understands those terms. And this has been one of the areas that is controversial even when we are fighting these matters in court, where the terms are unclear. It is not uncommon to come across cases where the employer cannot tell you what the actual salary of the employee was, the real salary of the employee, and has no documentation to prove to demonstrate what the salary was, which is an indictment on the part of employers. Salary or wage is one of the core elements of a contract of employment. In fact, if you look at the definition of the term employee, the only element mentioned in that contract, apart from saying that it's a person employed, it says a person employed for wage or salary. It doesn't say anything else and includes an employer is an indentured learner. So salary is very important in employment. So there ought to be certainty. How much is the employee earning? What is the progression? Is there a date of increment? Even things as banal or mundane as promotions. This one must be very clear so that the employee is aware. Again, we come across cases where an employee is saying I was entitled to a promotion, but I was not promoted, so I should be compensated for the promotion that is foregone, which is a bit difficult for the court to do. I think that is the farthest I can take the introductory part. But before I pen off from that, it is important to appreciate that, and this is a fact that we all know, that Before the 2nd of June 2008, employees were serving actually at the pressure of the employer. It was very easy for an employer to fire an employee. There are no major formalities. But after that date, when the Employment Act and other statutes came into operation, the framework of separation changed, and changed for the better for both employers and employees, as dictated by the changes in times and development of the economies of the world. Well, generally speaking, separation can take various forms, actually very many forms. And it all depends on what the parties have agreed, or what the parties will agree, because the parties can agree. The most basic way of separating is by agreement. The simplest and the most cost-effective way of separating is by agreement. And separation by agreement is underpinned on some principle that says that whatever is created by agreement may be extinguished by agreement. There's a maxim to that effect. Whatever is created by agreement may be extinguished by agreement. If the parties agree to contract, then we can also agree to terminate that relationship contractually. And the best way of going about it is a bilateral, where both parties, well, you remember that element of consideration in the law of contract, where both parties, it's a give and take. That would be very easy to terminate an agreement. And we have seen them. They are not very common, but a serious employer ought to explore termination by agreement when it becomes clear that the parties cannot continue in that relationship called employment, or circumstances render it impossible. A good example is the COVID-19, which of course employers are not faced before, employees are not faced it before. The uncertainty created by the restrictions imposed on account of that pandemic was not good for the employment sector, for the commercials, for anything. And some employers, of course, brought their employees together and agreed how to navigate it. This is a situation where discharge by agreement or termination by agreement, I would say parties just agree to separate, would have worked. Some employers navigated it well. I came across a case where a company did it very well. The parties entered into a settlement agreement. They agreed. There was consultations on email. The employee was given time. It's a very senior employee in this corporation. And the contract was sent to him and he signed. But of course, the matter ended up in court because the employee wanted to be paid more. And anyway, that did not happen because there was a clearly articulated settlement agreement. That is termination by agreement, mutuality, where parties just agree, whether it's by doing something in return for the other. But there are other mechanisms of terminating or bringing that relationship to an end. For termination by agreement, it is important to pinpoint. It can be initiated by the employer. The employer has more experience, is more aware of what is happening, is better placed to initiate the process, but give the employee time to digest the idea. The same should not be in a hurry. Time, they say, heals more than a doctor. So employees should be given time to digest what has happened, study the proposal. If they want to seek legal advice, they do so. And if the deal is good, then they can proceed and agree. That can also be done at the instigation of the employee, although the employees do it by way of resignation, which is a unilateral method of separating. A resignation is a withdrawal by the employee of the employment relationship. Of course, the contract will ordinarily provide what the formality is the giving notice by either party, a requisite notice. Of course, resignation also brings controversy in relation to notice, in relation to cause of resignation, because sometimes it could transition to a constructive dismissal, depending on the circumstances of the case. Of course, that is an avenue employees use, and sometimes if the circumstances and the evidence available justifies, the court will hold that there was a constructive dismissal. But in very many of the cases, that is not the case. Of course, to amount to a constructive dismissal, there is the test, the principles applicable, as have been formulated by the courts. And the court must subject the evidence and the circumstances to that test to ascertain whether indeed this was an involuntary resignation. But the most important thing that guides the court is the letter of resignation, because when we resign from an employment, we vent out the reason why. Well, personal reasons, that cannot be amount to a constructive dismissal if there are personal reasons. But if there are challenges that the employee has been going through at the behest of the employer, the employee will catalog them there. And some employees do it very clearly, saying the reasons why. I didn't want to leave the job, but this happened, a chronology of events. That is very instructive in guiding the court as to why the employee resigned. But in either case, a resignation is unilateral and becomes effective as soon as that letter is received by the employer, or the words are echoed to whoever they were made. I'm leaving employment. I'm quitting the job. Well, but interestingly, cases have a reason where the employee comes back and says, I've changed my mind. Well, I haven't come across that case, but I know there are cases where employees have changed their minds, and sometimes could be they have a reason of changing their minds. But in law, strictly in law, once one of the parties unilaterally withdraws from that relationship, then the coming back can only be at the mercy of the other. It is like a termination. If the employer terminates an employee, and then after a week, it wants the employee back, the employee may say yes or no. And the same would apply to a resignation, in my view. Unless, of course, every case is dependent on the circumstances. No two cases are similar in every respect. Because one is at the instigation of the employer, the other one at the employee. But each case is guided by the evidence available. The other ways of separation that generally have not caused a lot of controversy, things like passing on of an employee, even permanent incapacitation. There are ways of doing that without occasioning acrimony, which fight the way to the courtroom. Illegality generally is rare, where the contractual relation becomes illegal for unexplained circumstances or over which none of the parties has control. A contract of employment at common law generally cannot be frustrated, but there are situations, actually, there's case law that the contract can be frustrated. Could be by even I've seen cases where it was held that the contract was frustrated by the COVID-19 pandemic, the restrictions, as well as the force majeure clauses. But at common law, it ought not to be frustrated. But there are supervening events which also could occasion a frustration of a contract. And that is where the COVID-19 pandemic came in. I haven't touched on termination generally, because that is the focus, and I hope I have a few minutes to do that. For purposes of the conference that Esther and her organization are organizing, termination will only be one of the topics to be covered. Of course, termination of employment is such a wide topic, an involving topic, that the few minutes I have here cannot, even if it was an hour, one cannot do justice to that topic. Because there's so much that can be said about that topic, whether it's an ordinary termination or dismissal. There are too many aspects and facets. There are so varied circumstances in termination that sometimes general rules don't apply. And bearing in mind that each case is decided on the basis of its own facts, then the playground for judges is very wide in that respect. However, that is constrained or constricted by the law to the extent that certain things must be demonstrated. If they are not demonstrated, then termination is unfair. Part 6 of the Employment Act is the relevant part in the termination of employment, all the way from notice to the remedies or the reliefs that are available under Section 49 of the Act. Just before I go down to termination, there's something I've remembered, a case I came across where, when I was talking about the terms of a contract, let me take you there for a minute or two. And I talked about the clarity of terms. I didn't want to go to case law, but there's one interesting one I came across very recently, where an employee's contract came to an end. And it was a fixed term contract. But there was a clause in the contract suggesting that the contract would not end. It would continue, but in a different way. And when the employee came to court to enforce that clause, it was contested vociferously by the employer. The employer argued that that clause was void, it was illegal, it was unconstitutional. And the employee had served for over 10 years under that contract. So it was quite an interesting case where it is the employer contesting the terms of a contract, which has already been concluded because the contract actually gave the employee the right to remain in employment. And it was strange because it was the chairperson of the organization came to court and also argued that that provision was unenforceable because of this and this. All reasons were given. Unfortunately, the court was not persuaded that that clause was unlawful, it was illegal, because it was a bad deal for them. Sometimes employers can also swallow their pride and say, well, this one I goofed because I included a term. It was a term of a contract that was copied word for word from another contract without any of the persons looking at it seriously to understood its implications. Well, but they indicated they would go to the Court of Appeal. That case introduces the other mode of separation, which I hadn't mentioned, which is a fixed term contract, which is by a fraction of time. Fixed term contracts are very easy to deal with between employers and employee. Nothing much is expected. Unless the contract provides for notice, no notice is required. If the contract provides for a notice should be given. If the contract provides for extension, then, and there are no conditions, the same should be done. If it provides for renewal with conditions and the conditions are fulfilled, then the extension should be put in place. But sometimes they can very messy, where the contract itself talks about extension subject to performance, and the employer says, well, the employee's performance was not good, yet there was no performance appraisal. And this connects with what I stated earlier. If the human resource manual or policies or regulations provide for performance appraisal and also provide for performance improvement plans or performance accelerator plans, then it behooves. It is incumbent upon the employer to comply with those provisions on the performance improvement plan. And we cannot have a performance improvement plan if there has been no evaluation, a proper evaluation. Whether it's the balance scorecard or whatever, the court does not worry about that. As long as there's a proper, the targets were set, there is time duration, the employees get a chance to do that, and then they are assessed. And both agree those are the scores of the employee. I came across a case where an organization has a very, very elaborate performance appraisal system and performance improvement plan. The human resource manual provided that a performance improvement plan would be for a minimum of 3 months. But in this case, the employee was given, I think, 2 of them. The third one was 2 months, and the employee was. So if your documents provide that the performance improvement plan is for 3 months, or 4 months, or 6 months, then you have to obey those provisions. They're yours. They are not temporary platitudes. No, they should be obeyed. And if they are not, the court may not be inclined to reinstate, but it will order compensation because of breach of contract. So termination generally, how do employers avoid pitfalls? I'll be a bit general here. Could be based on experience I've seen, and I'll know specific cases. In the termination letter, the employer is supposed to look at the contract itself. Look at the contract itself. What does the contract provide? How many months notice? I'm assuming it's an anonymous separation, anonymous termination, not dismissal. How many days notice? Then give the employee those days or pay in lieu of notice under Section 36 of the Act. Pay off the leave days, if any, that have accrued, any overtime that has accrued, any bonuses that have accrued, etc. And if there was a contributory pension scheme, direct the employee to where he or she is supposed to go to claim his money. That letter of termination must be very clear, very, very clear, and must tell the employee, we terminated your services for this reason or for these reasons. Remember, I started with the letter of employment, the letter of termination. These are the reasons. But that letter is the culmination of other activities, the other preceding or antecedent activities that took place, which culminated in that letter. Now, there ought to be consistency in those other activities and this letter. The letter should be a reflection of what has transpired before. If there was an interdiction letter or suspension letter, there ought to have been a reason for the suspension or interdiction. If there was a notice to show cause, there ought to have been a reason for the notice to show cause, so that there is consistency, there is some congruency between all those letters. Sometimes there are more than two before we get to the termination letter. Sometimes employers shoot themselves in the foot by having reasons in the letter that were never brought to the attention of the employee. Remember the Employment Act and the Constitution, Article 41 and Article 50 of the Constitution. Those two articles and then the provisions of the Employment Act introduce due process in the termination process. And that is very critical. It all depends. Sometimes even the provisions of the Fair Administrative Action Act apply. So it is the duty of the employer to ensure that there is that consistency. Some of us are in a hurry to have the employee leave, and sometimes it is justified. In any event, dismissal is legal. Section 44 of the Employment Act provides for that. It is legal to dismiss an employee without notice or by a shorter notice. It is express. And then, of course, the reason will show to justify the dismissal without notice or with a shorter notice. But it's always advisable to have even that 1 day notice or 1 hour notice. What are the reasons? But typically, even at that 1 hour notice, it is important to hear the employee. Very important. Whatever what the employee has done, it is important to hear them. In writing, let them respond in writing. Incidentally, when an employee is given an opportunity to write, in response to a notice to show cause, they indicate exactly what is in their head. And if they do so by hand, that is even a better way of expressing themselves, because there's no mechanical intervention between the thought and the hand. We write what our mind is telling us. A handwritten letter is very, very truthful, unless we are dealing with a fraudster. The employer ought to be given, and they should be given time to respond. Not 24 hours. 2-3 days are sufficient, depending on the allegations. Of course, if the allegations are grave and they are based on documents, then those documents should be given to the employee. If they are based on a report, some audit reports and investigation reports, that those documents should be given to the employee. I came across a case where an employee was being subjected to disciplinary proceedings for an audit query. This was in a state body. Audit queries by the Office of the Auditor General are sent to the CEO of the organization. And they're supposed to be responded to by the organization itself, not by the auditor or by the HR or by the accountant or by whoever. The organization comes together and decides how to respond. But using the documentation they have, they respond. In this case, the responses were done and they were sent. But the organization did not avail a copy of that to the court. And the employee was being accused on the basis of the audit query, because it was on the employee's employment in terms of qualifications. And the employee's argument was, which the court bought, how did you respond to these allegations? You never brought them to this audit query. You never brought it to my attention to see that indeed there was an audit query. How did the organization respond? Because that response is not individual. So the audit query can only precipitate disciplinary proceedings if the organization does its own investigation and discovers that indeed there is a problem, and then may require the employee to respond. But that was, by the way, I'd gone as far as the notice to show cause, that I started with the letter of termination deliberately. I said, if the reasons the employee is being called upon to respond or suspended or being placed on interdiction are based on some report, some investigation, something that has happened before, or documents, then those documents should be given to the employee so that they can respond effectively to the allegations. Because at that point, they are mere allegations. But if there is some evidence on which the allegations are grounded, then that evidence should be given to the employee so that the employee can respond effectively. And many cases have been won on the basis of non-availment of investigation reports, audit reports, or the basis on which the charges were drawn. Well, 3-4 days are sufficient to enable the employee respond. They respond. The employee is supposed to go through those answers and see if the employee is saying something. But again, typically what very many employers do is, in fact, the letter of the notice to show cause has a date for the hearing. It requires a response, and it has a date for the hearing. That means they have already made a decision that this matter cannot, whatever the employee tells us, will not be sufficient, and we have to hear the employee. Well, to some extent is good, because the employee will be heard in writing as well as by word of mouth. The problem is whether those writings are never considered, because there's no evidence. Typically, employers don't provide evidence that they consider those writings. The minutes of the hearing can give some glimpse as to whether those writings were given consideration, but rarely do they. So those minutes are very important, extremely important, because they are the evidence that the employee was invited, although there ought to be a letter of invitation. And that letter of invitation should set out the agenda. Why am I being invited? Or make reference to a notice to show cause. And if there are any documents to be availed, they can also be attached to that invitation. The invitation, apart from the reason for the invitation, the employee must also be told the date, the time, and place of the meeting. You'll be surprised how many disputes arise on the, or there is contestation on the date of the hearing. And even when the evidence comes, there are different dates and there are no minutes. That makes the issue a bit complicated. Who do you believe? Of course, there is always some evidence that leads the court to believe one party as opposed to the other. A particular date at a particular time and venue, and the reasons for the invitation are given. The minutes should also be typical minutes. Who are the attendees? Who are the apologies? Who are participating? In what capacity? Who are the members? What was the agenda? Were the charges read out to this person? Had he been told that he was entitled to be accompanied by somebody, a colleague of his choice? Of course, there has been contestation again as to whether the person we bring is a lawyer. Some organizations have no problems with the lawyers. And my advice to organization is that don't worry about the lawyers. Let them be there during the hearing. If that is what the employee wants. Some HR policy says no, and that should be respected. As long as the employee is told, you have the right to be accompanied by a colleague, a fellow employee. The law says a fellow employee. Well, the fellow employee could also be a lawyer. But as long as it's a fellow employee, there is no problem. And they should be given the right to speak, all the parties. And the minutes must be captured in such a way that they tell the whole world what transpired, who spoke, who asked questions. And some organizations have done it very well. The transcript is very good. And it guides the court. This is what happened, so that it cannot be denied who asked what question, about what, and what did the employee say? Was he given a chance to make concluding remarks, which are very important? And the answer is yes. Are the minutes authenticated? And the answer is yes. So that is important. Then on the basis of those minutes, the letter is done and termination comes to an end. Well, sometimes the court is accused unfairly for finding fault on the part of the employer, that there's no way an employer can escape in a termination. There are many cases I've seen where employers escape from a termination. Why? They had a reason, and they complied with the procedure. These are the only two requirements. And there is more than innumerable case law about that, all the way from the Court of Appeal, the Supreme Court. We had a reason. And remember, an employer has a very important provision, Section 43, 1 and 2, and in particular, 43.2. And what the reason? The reason or reasons for termination of a contract of employment are the matters which the employer genuinely believed to exist at the time and which occasioned the termination. I'm sure most HR professionals who are with us and lawyers know there are two Court of Appeal decisions on that point. I think one is Naima Hamisi and Oxford University Press. The other one is there are more, Kelly and called Lewell Waithaka on that provision, which is very important. Because the court is called upon to ask itself a fundamental question, which is, this employer dismissed the employee on this ground. Would a reasonable employee in the same circumstances have dismissed the employee? That introduces the so-called the band of reasonable responses test in the Hasbury's Laws of England. Recently, I came across a case where a manager of an institution was dismissed for, I don't know whether it happens, it could be it happens in banks, for playing around with the employer's money. A customer comes to the institution, says, I have no money, but I need some money. I need 500,000 shillings, but I have no money. And now that the institution deals with money, the manager gives him the money. The man goes and says, I'll bring a check. He does not bring a check that day, the following day, the third day, the fourth day. The check comes. The check does not come at all. But unfortunately, a manager comes to that institution and decides to confirm that the amount of money in the system is the amount of money in the vault. Unfortunately, the 500,000 is missing after more than a week. So notice the manager says that amount must be reported and the customer must be called on to bring a check. And the customer brings a check on the same day, but in his name, so that when the check is honored, the money goes into his account, not in the bank account. Again, that check had to be cancelled, another drawn in favor of the bank. So the employee was dismissed. Would a reasonable employee have dismissed this employee? No money was lost. The check, of course, was paid later. The amount, so no, at the end of the day, no money was lost. Think about that. I think I've overshot my time.
No, it's fine. It's fine. Let's go on. Let's just go on. We
All
are
right.
keenly listening to how this one ends.
No, I didn't want to give you the answer to that. I'll give it at the conference when I give the facts of the case and how I reasoned. But it's an interesting one where something irregular is done, but no money is lost, but the employee loses the job. Think about that. Can I stop there and ask if there are questions that are burning, that cannot wait? I know I didn't cover redundancy. That is substantial.
Yes.
Yeah.
I'm thinking, I don't know, I don't want to tell anyone to answer that, but I think when we go to the questions, Justice GAKERI, there are quite a number of questions. I know, I see Richard. Richard has put his camera. I know he must have been thinking about that money that was lost. No, the money was not lost, but something did not work out. Now, Richard, in a minute, you're smiling. Talk to Justice GAKERI before I go to the questions, because I want to go to the questions very fast.
Thank you very much, Esther Katiba. Thank you very much, Justice, for that wonderful presentation. I don't want to jump into the last bits of what the Justice has said. I only want to ask one of the most prevalent questions that I normally see in WhatsApp platforms is when somebody has been told that you have a disciplinary case, then at that point they resign. What should be the best method of handling that, especially when it borders on criminal instances? What should somebody do?
Justice GAKERI, how do you want to handle that? You want to answer that? Because I see there are quite a number of questions so that we can go one by one. I don't know.
Let me take 2 or 3.
Okay, good. I think there was another one also from Richard here. I see, what is a general legal foundation for outsourced HR services? That is the second one we could possibly, and kindly let's mute ourselves except our guest. Psalm 91, please mute.
Let me start with the second one.
Yes.
Actually, there's a case actually that can't remember the name. There's a 3-judge bench on the matter that focused query on outsourcing, and the court tried to come up with some tests for outsourcing. Well, of course, outsourcing is a legitimate way of enabling an organization attain its objectives. It is known in the HR and other even financial world. It's a cost-cutting mechanism. It's more cost-effective. An organization nowadays even outsource services that are non-core, something like even giving employees tea, cleaning is the best known for being outsourced, but other services are also coming in. But this is dictated by financial imperatives, and there's nothing law can do about it. Law can only ensure that it is fair and not everything is outsourced. Of course, if the owners of the company want to sell it to another, again, the law cannot prevent that, but the interests, as long as the interests of employees are taken care of. Now, it may not have a legal foundation, properly so-called, but it's a contractual relationship between one company and another. So that unless there's something faulty about that contract, and in most cases it's not, if the employees are well aware about it, because they are supposed to be notified that we are outsourcing this service. So your employment will change. We transition from us to them. And could be what the terms will be if they are changing. So that, well, in most cases, problems arise because employers keep the information to themselves. And we could see that if we dealt with redundancy. The employee keep the information to themselves, and then the one morning, they tell them, this company is being closed because we have no business. That's the wrong way of going about it. The employees are supposed to be in the picture. If the company has financial challenges, let the employees be aware. After all, they are stakeholders in that organization, not as owners, but as employees, because they led the services. So the legal foundation, other than the contractual relation between the two companies, there's no other. But it's a legitimate way, and there is case law to that effect. Disciplinary matters bordering on where there are criminal cases. Well, of course, a criminal case and a criminal case or criminal matter offends the state, offends the public. So the public takes action through its established institutions, the police, the DCI, and the others. But that action also impacts on the contractual relationship between the employee and the employer. What the employer is supposed to do is to carry out an investigation themselves and see if there is evidence showing that this employee should be subjected to disciplinary proceedings. This could be as the criminal case is going on or after. Well, I know there's a Court of Appeal decision, that Supreme Court decision, that says that there are situations where double jeopardy could arise. But that all depends on the circumstances of each case. However, the employer is not bound to wait until the criminal case is concluded. because that's a different process. Anything that interferes with the contractual relationship between the employee and the employer, courtesy of the employee, can be the subject matter of disciplinary proceedings. Anything that affects that relationship. And the employer will be saying, I'm within my rights. Because my relationship with this person or these persons is contractual. They have obligations, they have rights, I have rights, I have obligations. Work must be done. But it depends on its own facts. Again, if we had a lot of time, there is sufficient case law to explore and see how the courts reasoned and perhaps why they came to the conclusion they did. Thank you.
Thank you, thank you. I see there's Isaac saying, hello, Your Honor. A common but unspoken HR practice involves advising or encouraging employees whose employment is no longer tenable so that they can resign or face a full disciplinary process. Is this having sound legal basis? And if the employee agrees to proceed as such, is this voidable? Now, the next one is great session. Please enlighten on discharge vouchers signed when separating with an employee. Under what circumstances can it be voided?
All right, let me take the first one first. Advising employees where the relationship has become untenable, advising them to resign. Well, depends on the tactic used by the employer. If they succeed, if they are able to convince the employee our relationship is not sustainable, it's not tenable, please resign. If the employee agrees, that's it. But they should be given time to think about it. Give them a day or so to sleep on it, think about it, and come up with a decision. Because it is instigated by the employer, directed at the employee. So let the employee digest it and decide what to do. However, if they decide not to resign and there is reason to subject them to disciplinary proceedings or process, that would be respected by the court if there is a reason. Well, the resignation, if an employee is advised, is talked to, and there is evidence that they were talked to, and they decided to resign, it is their choice. And they do it in writing. It does not matter where the idea came from. We internalize ideas and act on them, whether they are ours or from other persons. But by the time one writes down an email stating that they have accepted a particular proposal, then it is they are, as it were, expressing externally what their mind is thinking about. Discharge vouchers. Actually, most settlement agreements have a discharge clause saying that we are paying you, that the amount received is in full payment, final and full payment of all the dues, and one has no action. One undertakes not to file any action or any further action against the employer. Well, a discharge voucher is a contract. And some employers do it very well, where the terms are so detailed. And as long as the employee is given a chance to look at the document and sign voluntarily, because that's the word, they were aware of the clause, they appreciated its impact, and they made a free decision to sign that document. Remember, a signature binds the signatory. Unless there is a reason, unless there was a mistake, misrepresentation, there was duress, there was undue influence, or some other vitiating element, a signature is binding. And it's sometimes very difficult to avoid a signature, unless there's very good evidence as to why. But some employees sign it at a protest, which is good if you don't agree, or you qualify it. Just qualify it there and there in writing. I am accepting this amount as terminal dues only, and not for anything else. Which means that the aspect of further action against the employer remains. It does not discharge the employee. Again, this happens actually. Just put a rider there. I do not agree with this statement. Or not sign altogether, so that all matters are contested in court. That's the other option. But the moment we insert our signature, then we have to qualify that signature. If we are in disagreement with part of that, ordinarily what happens is that I've lost employment. You know, in life, one of the most addictive things for employees is a salary at the end of the month. A salary is very addictive, so that if you lose your employment drastically, it is devastating. And if the employer says, we'll give you 1 million shillings as terminal dues, unpaid leave and untaken leave, and all your dues is this amount, and one was in a very poor financial position, the likelihood of taking this amount is high because it will sort out very many matters. And 1 million shillings is quite some good money. But over time, of course, it will come to an end. And we discover that we are back to where we started. That is why, that is the excuse employees bring to the court. It's a reason, but at that point, it's an excuse. Because the point is, why didn't you call your lawyer or seek advice before you sign this document? Or why didn't you refuse to sign it if you're not given time to go through? Because you're supposed to be given time to go through, appreciate what it says, its full import, and then sign. Because trying to avoid the signature thereafter is difficult, very difficult, because it is binding. And case law, starting from English law to our law, signature prima facie means acceptance. Unless that signature is vitiated by any of the vitiating elements. And mistake, I signed a mistake. You see, you sign the wrong document, you can always plead what is called non-est factum. It is not my act, it is not my deed. That's for mistake. For misrepresentation, one can argue that, well, I asked the HR what that document was saying, and this is what they told me. But now I know this is what the document says, particularly for persons who may be challenged in terms of understanding the sometimes very meticulously drawn clauses by lawyers. That's the only way. If an employer can demonstrate that indeed they asked the HR or any other person to explain the particulars of the clause, and what was explained was different, then it is possible to avoid the contract. Remember, misrepresentation does not avoid the contract, but it does a contract avoidable, or if there was duress, which is very commonly used. There was duress, or undue inference. But remember, the duress is a common law principle, and it has its own elements. It has to be proved. who exacted the duress or the coercion? How many people are in that room? Was the person armed? How was the threat communicated? Was the threat illegal? Was the person capable of effectuating the threat? All those are elements which must be proof for duress to become enforceable. I haven't seen a case where it was proved myself, and it has been cited in very many cases I have handled. Why? Because the elements are not there. Sometimes it's just a mere excuse. You sign the document. Yes, I signed a duress. That time, the witness statement does not even show that there was duress. Just to reinforce that one, I came across a case fairly recently, a very interesting appeal, which again, the answer, I'll not give you the answer. It's a case where a young man was employed as a manager of a private school by the owner. I think he was employed out of the month of April 2022 or 2023. And he was paid for about 3 months, 3 or 4, but he was not paid for November, December, January. Then he was fired at the end of January. Fortunately for him, he had 3 written pay slips with the letterhead of the organization. That's all he had, saying 25,000, and some deductions were made. They were Dutch. He was getting the 25 actually. He wasn't getting anything. No deductions were being made. When he was fired, he went to the magistrate's court in that division or sub-county. And that is one of the most interesting judgments I've seen, because the learned trial magistrate reasoned that because the contract of employment was not written, and it was for more than 3 months, that contract was void. So it did not exist. But the trial court made a good finding that there was an employment relationship. But because it was not written, it was void. And that void or nullity was reinforced by the fact that the employee did not take any steps to ensure that there was a written contract or to obtain or secure a written contract. Very interesting. But I was handling the appeal. Yes. And I handled the appeal to the end and delivered a judgment about a month ago. I don't know. For that one, I can give the answer. The employee asked for house allowance, service pay, etc., and then compensation. That is a case where the employer was so audacious that he did not even file a witness statement, but came to court. The owner of the school came to court and gave evidence, and he had nothing to show that he was even the owner of the school. He said this gentleman was a casual worker, and I used to pay him 1,000. And he had no evidence to show even he was paying him 1 cent. But the landed magistrate heard him, which is good, and recorded the evidence, which I used to find him liable as the employer. So the employee who had appealed succeeded in the appeal and was awarded compensation, among other things. Thank you.
Wow. Wow, I see questions still coming, Justice GAKERI. But I like the fact that you said I know you will be with us in Naivasha on 4th to 6th of June. We have a conference. We will be addressing navigating employment and labor relations in Kenya. Now, we will touch all these areas from disciplinary, policy document, contracts, health and safety, redundancies, and all this. And Justice GAKERI will be on site to take us through. Now, at that point, you will be able to have one-on-one conversations with Justice GAKERI, but the poster is in the chat, kindly. It will be Naivasha 4th to 6th of June at the Sawela Lodges. Check that out. Let me go to the next one, Justice GAKERI. And it's amazing we still have the 98 people going 100 on call. That this tells us that this is a very important conversation. Now, termination on grounds of poor performance is arguably one of the most contested area that an employer ends up losing, especially on procedural fairness. Now, kindly enlighten on this, more so on the documentation to keep and the overall procedure. I think I can just look for another one. With the stop work orders from the US government, would we be right to say that frustration of contract would be the right thing to do? Do I pick another one?
Yes.
Good. The third one is from Peter. He says, please enlighten us on the issue where one is put on, I think, on employment without a letter of appointment and is underpaid for years, contrary to what was agreed orally. How can one recover the difference accumulated over the years? So I think that would work before we take the other three.
Let me start with the last one. Employment without a written contract. Then there is the payment. Of salary. Well, typically what courts would want to see and hear is if the contract was unwritten and there was the payment. Did the employee raise the issue with the employer at any point? Because we see cases where an employee comes to court 10 years later and saying, well, I was underpaid 10 years ago. So what did you do? Self-help mechanisms, do an email, do a letter, something that shows that indeed this is happening. A letter or email and keep a copy. A letter or email, the intern never forgets. That is what you bring and say, well, I wrote this letter to the employer telling them that they are paying me. So they are indeed paying me. And because this is what we agreed, and they are not this. Even where, particularly in this age, even where an employer tells an employee, I'll be paying you 50,000 per month. The employee, an intelligent employee or a prudent employee will do an email to the employer. That's an email, not expecting a response. Hereby is to confirm our conversation earlier today or yesterday about my employment. And we agreed, and I'm in agreement with you that the sum of cash shillings 50,000 is my salary. That is, it does not have to be responded to. But as long as it is making reference to discussions that actually took place, because ordinarily we don't like emails for the sake of it. They are communicating something. So the question would be, this person even has the email of the boss, and this person is discussing a discussion they had about the salary and is confirming what they had agreed. So indeed, unless the employer adduces better evidence to show that the salary was different, then the employee is likely to win on that score. I know, but it will be difficult to recover more than 3 months, if more than 3 years, if there's no evidence to show that the employee is the issue. Self-help mechanisms are very important. That is why compliance with even internal dispute resolution mechanisms is very important. It's a self-help mechanism employee should take up. Question 2 was on stoppage by the absence of funds. These are things that should be brought to the attention of the employees by the employer, so as to show that they have inability to pay. And that this can be a supervening event which frustrates the contract. We can also use force majeure clauses. It qualifies as such. But the better way of separating is a redundancy. That would be the best. So that the employees are aware. Of course, all of us can understand now. If a project was funded by another jurisdiction, 100%, and there's no money anymore, of course, where would the employer get the money to pay us? But they are supposed to sit down and agree how the separation should take place. But it qualifies as a frustration. Poor performance. Yeah, poor performance is very tricky, actually. Very, very tricky. But it is based on the contract itself. What does the contract say? What does the contract say in terms of evaluation? Targets, their targets are set. There should be evidence that the company has a performance management system. It has a performance evaluation system. A performance evaluation assessment is part of the performance management system. That yearly or quarterly or half a year targets are set between who and who. So were the targets set? So there should be evidence the targets were set. And then there was an evaluation. There ought to have been a meeting between the employee and the supervisor, if that is what the manual provides. Typically, it is the supervisor who evaluates the other employee. And the employee, if there are other persons who report to them, they also evaluate them. But there should be evidence that the evaluation took place, and this was the score. And the parties agreed. There is an agreed score, and the parties signed. All this must be signed. Well, some employers try their best, but they never demonstrate that the meetings took place. The evaluation session is important. It must take place. Who are the parties? The supervisor and the employee. And this is what they agreed, and they signed the document, the evaluation. Some do it very well. It can even be that there is a performance improvement plan, which is good, giving the employee time to improve. About 3 months is sufficient. If the employee is not improving, they should be called and told your performance is not improving. And we think it's the high time we take this discussion to another level, the level of separation. At that point, that is where now the employee should be told that there will be a disciplinary meeting. And then they are told to bring a fellow employee. Because it is based on performance. Well, the employer can still do a notice to show cause, although a notice to show cause is generally done even before the performance improvement plan comes in. But the employee must still be given the chance to appear with a colleague or fellow employee of his or her choice. And then the charges is read. Everything follows the sequence of events in an ordinary termination, even where the employee has failed to enhance improvement. But the documentation is very critical. The manual, of course, will tell us that there is a performance management plan, performance evaluation. Then the minutes and the document, the evaluation document. These were the targets that were set. You see, the target and the evaluation document is typically 1. If there are 2, then there should be 2. The evaluation, so there is the targets, self-evaluation, agreed, etc., and then the score. If an employer has all those documents, it shows that they have implemented their performance management system and their performance evaluation system in relation to a particular employee, and the employee's performance can be shown, has been shown, and can be shown evidentially to be wanting. and then they are taken through the process of being called, even when the performance improvement plan shows poor performance, they should still be called by the supervisor and told, your performance is not improving, it's not good. So we think we'll terminate your employment. So then they are told, they're invited for a meeting on a particular day. And they are told why they are being invited for that meeting. And they are told the right to bring a representative, or not a representative, but a colleague of their choice. And if there are documents that may assist, then the employee should also be given those documents. And a hearing takes place, and the employee defends himself or presents his or her case, and is heard and a decision made. I hope I have answered the 3 questions.
Yes, you have. And I'm still here thinking, I think this Naivasha conversation is going to be very nice. I think I will almost ask you to list 1, 2, 3 for us in Naivasha so that we don't make these mistakes again. Now, Eric asks, can government directives lead to frustration of contracts? The next one is kindly clarify on the issue of legitimate expectation as far as contract renewal is concerned. How can this open up an organization to litigation? And the third one, Anne Wawero asks, when a fixed contract has ended, does one need to be paid notice?
Well, I'll start with the last because it is the shortest and the simplest. The challenge with fixed contracts is that employers burden themselves with detailed clauses about a fixed term contract. A fixed term contract, as the name suggests, means exactly that, fixed term. And a prudent employer who does not want to be involved in litigation should say, I'm employing you for 5 years. From this date to that date. That is all. You can, but you can add another, renewal is by mutual consent. Or renewal it at the discretion of the employer. Full stop. But the moment you add stories of performance, that complicates the matter. But some employers have become a bit funny, and they give one employees, particularly the low-cadre employees, 1 year contract, 1 year contract. That is an unfair labor practice. One year contract, one of it for 20 years or 15 years. But if they are separated, so others separate them, then they are new contracts. No notice is required in a fixed term contract unless the contract so provides. No notice is required. So no notice is payable for a fixed term contract. Why? Because it terminates by a function of time. I was employed for 5 years or 4 years. The 4 years have lapsed. I knew that. But if the contract so requires, then the employer is obligated to do that. Well, there are some that ties to the question of legitimate expectation. And this was discussed very well by the Court of Appeal in Transparency International and Caro Omondi. It all depends on what the employer does after the term expires. When the term of the contract lapses, or before it lapses, is there evidence to show that the employer intended to renew that contract? Because sometimes there's evidence. I've come across one case where there was some evidence And I thought it demonstrated that actually the employer had even told the employees, an email was written that I'll be forwarding your contracts, because the system was that the employee had to indicate in writing that they are interested in continuing to work, and this employee indicated, and there was email communication, and the last email was, I'll be forwarding the contracts, but the contract was not forwarded to this employee, and they came to court. And I thought there was some expectation. We call it reasonable expectation. Actually, this is another court of appeal decision which says that it's not legitimate. Because legitimate expectation is a public law principle. So that court of appeal decision says, no, there can only be reasonable expectation, not legitimate expectation. Yes, it is possible for an employee to argue that they had an expectation that the contract will be renewed depending on what the employer does or does not do. It can be an actual omission which shows the employee that the contract will be renewed. This, of course, varies from case to case. Like in that case, I have demonstrated, and there are also others where the employers were held to have created that expectation. Not one, actually many of them, particularly in the Employment and Labor Relations Court. But the issue was also referred to in that case of Transparency International, Caro Mondi. So I think I have covered those two. Government directive depends on what the government directive does. A government directive can frustrate a contract depending on its impact on the relationship between the parties and third parties as well. Could be the best example I can give is where we are working at a construction site and the government directs that the building be demolished or construction stops. There's nothing the employer can do about it. It's an external thing. So it's a supervening event and to frustrate that contract. That's my opinion.
Good. I see someone asking, they joined late, whether there's a recording. We are live on our YouTube channel, Conversations with Esther Katiba, so you can watch this. We will also share this on our LinkedIn, Esther Katiba. So that's it. Justice GAKERI, this doesn't seem to be ending. I am seeing very many questions here, which I think I'm feeling like I'll be unfair, but I am seeing so much. I don't know what you think, because I see so many questions here from...
Let me take the last 5.
The last 5, right?
I have a cold. I'm struggling also. I have a cold.
Okay. So maybe we touch on termination on medical grounds or incapacitation. Let me see. Forgive me, audience, if I know he has touched on PIP, so let me not go to that one again. Stop work orders, I think he's touched on that. Is it mandatory to, yeah? Or you want me to read that one? With a stop work order from the US government, a new hire was to report during the time. You touched that, isn't it?
Yes, I addressed that. It was us, actually.
Yeah, I'm seeing it coming up again. Is it mandatory to transcribe the deliberations of the disciplinary meeting? Let me just, what happens to cases of sexual harassment where you have said we share the report of investigation with the accused, and how do we protect the witness if we must share the documentation? Let me look for 1 or 2 more. And for the ones we won't answer today, I think, again, I'll say we meet in Naivasha, 4th to 6th of June for the conference. And Justice GAKERI and other judges will be on site to help. At common law, the bank case was in the, okay, let me leave that one. I think that was an answer to what you had said. During restructuring that leads to redundancy, retrenchment, what is your legal guidance on how to manage staff on fixed term appointments, given the stipulations of the Employment Act on severance pay? Would that be, will that be okay? I think Justice GAKERI, for now.
Yeah, that's all right. That's all right.
Good.
I'll start with the last one. Restructuring leading to redundancy and then fixed term contracts. Well, typically it does not matter whether a contract is fixed or long term when a redundancy comes, as long as the law is complied with. The provisions of Section 40 are complied with. Remember, it's a termination of employment available to the employer because the employment relationship has become untenable, not because of the conduct of the employer. Actually, this is a termination where the employee is free from blame. But as long as the law is complied with, and there's no problem. Well, the fixed term contract holder is entitled to severance pay as well, like the others, but only for the year served. Only for the year served. Sexual harassment, well, where the evidence touches on the witness, well, what can be done is we can remove the name of the witness on the statement that was made, so that the employee is aware that there was a name. Somebody gave that evidence. Alternatively, if the employee is too uncomfortable releasing that information, the same can be given to the employee at the hearing, but they are given sufficient time to go through those documents, even if it means adjourning the hearing for some time to accord them time. But they must have that evidence, because that's the evidence that the employer is relying on. And the employee is in law entitled to that evidence. So they ought to be aware, which accommodates both parties without compromising the witness statement, the witnesses. But the statement ought to be given to the person. Well, I came across such a case that I did not have, I left the station before I decided that matter. So I don't have that wisdom for now. But it calls for the exercise of discretion on the part of the employer. What serves both parties? The best that serves both parties. Remember, in a termination, the law is very particular about the weaker party. The party being thrown out of employment should be protected, should be accorded all the rights to ensure that the process was done fairly and accommodated that person in the best way possible, so that if a decision is made that they leave employment, then they'll go knowing that they were given a chance, and they actually presented their case effectively. On transcription, and well, the law does not require, even court don't require that you transcribe, but give complete minutes that reflect what transpired on that day. Minutes that can give a very clear impression of what happened, who asked what question at what stage, what will the answer, everything that happened. If you can't transcribe, then somebody should record them. I have seen even very serious organizations where minutes are taken by hand. Yes, and they work. Judges record evidence by hand, and it works. But over time, of course, there will be transcription. So reasonably written minutes are sufficient for purposes of the disciplinary hearing. Signed, complete minutes, not a few sentences. Sometimes it's a half a page. It don't say much. Medical grounds. This can also be a negotiated thing to ensure that if the person is unable to perform, of course, the Employment Act has provisions on what happens, how one is paid and how one can be eased out of the employment if they are very sick. Even incapacitation, if one is incapacitated in such a way they can't perform their work. The best approach would be to sit the employee down so that the cards are laid on the table by the parties. This is the position. We gave you the 3 months and paid you. We gave you the other months, paid you half salary. We have even extended it, but still no services are being rendered. So as much as the employer would want to keep the employee, a time comes when they have to part ways. If the employee is unable to perform, as long as they are given a chance to state themselves, of course, the employee will say, if there is an opportunity that the employee can be given, so that if the work was difficult, they are given lesser work. If the work involves a lot of exertion, they are given work does not require a lot of exertion. If there are those opportunities and there is evidence that they were explored by the employer, then a declaration of redundancy would do, or just by agreement. Parties agree, they negotiate. These are the terms of separation. If the employee agrees, the better. If the worst come to the worst, well, they are given a letter and told us we've done our best. And if they are that termination challenge in court, the court will look at the evidence available and make a decision. I think I've tackled virtually all the questions, haven't I? Unless it's the last one, you cannot wait.
Yes, I think you have, and I'm getting, allow me to put that on the screen. I'm getting a lot of chats to reshare the Naivasha conference. And Justice GAKERI will be with us in Naivasha amidst other judges and CEOs and also some legal professionals. We are asking the HR professionals, health and safety, legal professional, business leaders, business owners. Our conference will be on 4th to 6th of June 2025 at Sawela, Naivasha, and we will delve very deep for those days into navigating employment and labor relations in Kenya. Now, all these issues on discipline, policy documents, contracts, health and safety, termination on medical grounds, and all the questions that you have will be answered within those days. So there, I will put that flyer there, as I also thank Justice GAKERI. Thank you very much for the time, and I know you're not very well, but you actually even joined very early. You are on call very early. So for those on the call, I see we are still 82. Kindly, you can take a photo of that, but we will share this on our LinkedIn. My LinkedIn platform is Esther Katiba. We are live on our YouTube, so you can still access this. For those in the HR groups, we will share this as well. There's a number there. So feel free to chat with us, to drop us an email at training@careerrootesolutions.com. For that, Justice GAKERI, thank you. We can't thank you enough. You have enlightened us and saved quite a number from seeing your doors. And other organizations are rejoicing because a lot of knowledge has been gained. But thank you, everyone. I look at the time, it's actually 9. It's actually 9. So allow me to end this here. I will still reshare. I know I've stopped sharing, but I will still reshare that as we close. But thank you, Justice GAKERI, for your time, for sharing with us all this information. It is very kind of you. I don't know, someone on the call, can someone volunteer to just give a vote of thanks to Justice GAKERI? Just someone on the call. You can unmute. It's your moment to speak to Justice GAKERI.
Yeah, good evening, everyone.
Good evening,
evening.
Simon from TZ.
Yeah, my
Thank
name
you.
is Simon from Tanzania. Yeah, I've been
Welcome.
part of the Kenyan HR team in all your webinars, learning here and there to get insights. So may I take this time on behalf of all 73 people on the call to thank Justice GAKERI for the insights he has given us today. Of course, we have learned a lot, even though the time was not enough. So may I call upon everyone to go for the coming prepared event in the place where Esther mentioned, where we are going to get more insights. Because when it comes to labor matters, especially experience in courts and whatever never ends. Every morning you are getting new insights. Every morning you are getting new experiences and knowledges which might make you more competent ahead of our practicing the employers every day. So thank you very much, Judge. We hope to see you in the upcoming event in June. Thanks.
Thank you very much, everyone. It was a pleasure. Have a good evening.
Thank you, everyone. I'll leave the poster up so that if anyone wants that, they can have that information. Justice GAKERI, have a good